Okay, I'm going to say good afternoon, NYU Washington, from your friends and colleagues at NYUL, New York University in London. We are delighted to join with you today for what will be a rather short video conference, I'm afraid, celebrating and exploring the 800th anniversary of Magna Carta, that great medieval charter which, shaping the future relations between the monarch and the people, helped transform the course of UK and then also US history. My name is Philip Drummond. I have the pleasure of acting as moderator for this session. I specialise in film and questions of cultural history and identity, and I'm also the curator of a little programme over here of special Magna Carta anniversary events, of which this video conference is an undoubted highlight. We've been off to the magnificent British Library commemorative exhibition just down the road from here. We've screened the BBC's splendid recent documentary by David Starkey on Magna Carta. And at the end of this week, we conclude with a day-long outing to Runnymede itself and to Windsor Castle. So we are doing our best at this end to fit in with the broader celebrations of this extraordinary occasion. We're extremely grateful to internal and also external colleagues from the university world who have kindly loaned us their time and their immense expertise to make this video conference possible. Expert colleagues at this end, whom you can, I think, can you see them in the photos on a screen at your end? Expert colleagues at this end are NYUL Director Gary Slapper, sitting next to me, Prof. Scott Kelly sitting at the other end of our table, and we are even more fortunate that a very, very important, a major Magna Carta scholar has been able to join us today, Professor David Carpenter of King's University of London. At your end, we can see you. We're delighted to meet Prof. Marvin Estrada of NYU Washington, and coming in from the Georgetown University, we're honoured to be joined by Prof. Renee Leto-Lerner. Renee, great to meet you. Thanks again to you all and to all the university's guests in London and in Washington. Please enjoy what we hope will be a most interesting, but also, we insist, very relaxed show indeed, we think. In the course of our hour together, we intend to cover three main stages in the long life of Magna Carta. David Carpenter will set the document in its historical context for us, and we therefore look forward to the brilliantly meticulous work which he's carried out to create his new Penguin Classic edition, published, I think, just a month or two ago. So really, really lucky to have somebody who's had his hands on the material. Then we propose to look at some of the legal ramifications of Magna Carta past and present, and here our legal beagles Renee and Gary will be the main contributors. The wider implications for UK and US political and constitutional arrangements will be the focus of the third segment of the hour. Here, Scott and Marvin will be suggesting perhaps some more contemporary perspectives on the enduring significance of what might otherwise be seen as a rather ancient text. And if time permits, we'll conclude with a free-for-all around the table on what the British Library, in its strapline for the current exhibition, calls Magna Carta, Law, Liberty and Legacy. So I'm going to get us going at this end, if I may, by turning to David Carpenter and asking him, how did a piece of sheepskin with 4,000 words of Latin in medieval script come to be, and why was it so important that it came to be?
Well, thank you very much, Philip. And can I say what a great pleasure it is to be here to talk about a document which originated in England, but which has been tremendously important in American history. And of course, as you all know, it was appealed to again and again by the founding fathers of the American Constitution, and in Supreme Court decisions about the Constitution over the last 200 years. Again and again, Magna Carta is cited. So, where did it all begin? Well, it is indeed the 800th year anniversary of Magna Carta, because it was on the 15th of June 1215 that King John authorised the sealing, and please don't anyone say he signed the Charter, he authorised the sealing of Magna Carta in the meadow of Runnymede between Windsor and Staines on the 15th of June, in the 17th year of his reign, which is the 15th of June 1215. So Philip said, well, what is the document? It is indeed written on parchment, on specially prepared sheepskin. It's just under 4,000 words long. It's, of course, in Latin. And I think it's worth remembering there weren't just one single Magna Carta. John issued probably, certainly 13, I suspect probably 20 of them, over 20, over a period of a month, stretching on from the 15th of June. And all of those have equal validity. Only 4 of the originals now survive. 2 are in the British Library, 2 are, one is at Lincoln, one is at Salisbury. And they were all brought together actually earlier in the year, just for a very, very brief period. First of all at the British Library, and then in the Houses of Parliament. The reason why they couldn't stay longer is that Lincoln and Salisbury wanted their charters back for their own exhibitions. So, in a way, the fame of the Charter, it does seem odd. After all, it's a Latin document, it's full of those obscure terms which give medieval history a bad name, like amercement, novel disseisin, mort d'ancestor, distraint. It seems to have clauses which have very sort of narrow significance, like getting rid of fish weirs on the River Thames and the Medway. It's also, of course, a very hierarchical document. I mean, it reflects a very unequal society and in many ways reinforces that unequal society. So it offers nothing to the unfree, who constituted well over half of the English population. Indeed, it actively discriminates against the unfree. It takes a very, very mixed attitude to women, and the most famous clause of all says no free man is to be outlawed in prison, save by the lawful judgment of his peers or by the law of the land. And when it thought of what kind of assembly could actually give the consent of the realm to taxation, it thought entirely of a House of Lords. It didn't have time for towns, it didn't have in the assembly any room for knights representing the county. So it was a House of Lords, not a House of Commons. So we may well ask, how on earth has this charter, reflecting very much the social hierarchy of the age, become so famous? I think one essential reason for that, before any others, and that is that although a benefit only to a narrow section, or to any rate the top section of society, it does assert a fundamental principle, namely that the ruler is subject to the law. If he wants to act against you, provided you're free, that is, he has to do so by due legal process. And Chapter 39, the most famous of the Charter, sums that up when it says that no free man is to be outlawed, imprisoned, arrested, deprived of his property, save by the lawful judgment of his peers, means his social equals, or by the law of the land. And that means that the king can't just say, off with your head, into prison, I'm seizing your property. If he wants to act against you, he has to do so by due legal process. So that's one important factor in what makes the Charter so important. The other is its tremendous success. The Charter was not, as it's sometimes been claimed by pundits this year, a sort of merely guff or has no importance in the period. It is a watershed between lawless and lawful rule in the 13th century itself. First of all, it becomes tremendously well known in its various incarnations. It's the 1215 Charter, but its successors, so the final definitive Charter, was that of 1225. They're copied again and again in the 13th century. You can find them in legal collections, you can find copies in chronicles. Lawyers are fascinated by it and write all sorts of little memoranda about it, comparing the different versions. So, it's not just a venerable symbol, a vague symbol of good government. It's much more than that. It's sinking deep down into the hearts and minds of the political community in the 13th century. And also, it does make a real difference to royal rule. I mean, the kind of arbitrary conduct of kings before 1215, King John and his predecessors, does just disappear after 1215, or disappear in very large measure. The king doesn't charge gigantic sums of money anymore to recover his favour and his benevolence. He doesn't force widows into remarriage. He doesn't seize property without lawful process. He doesn't charge people for large sums of money for justice in his courts. In all these ways, the Charter is making a very big difference to the whole operation of kingship and is really preparing the way for the tax-based parliamentary state. And so by the end of the 13th century, Magna Carta had established the basis from which it was ultimately to go round the world.
Thank you very much, David. Okay, I think we now know a little bit more about the world out of which this document emerged. But the fact remains, I guess, it is still a relatively remote world. So we're now going to turn to our legal experts to tell us why this text from 800 years ago should have such power over the modern world, perhaps, where we no longer have despotic, tyrannical monarchs at our head like King John. So I wonder if I can turn to Renee. And Renee, can you tell us why should we be interested in the legal ramifications of Magna Carta in the modern age?
Well, I'm going to look at it more from an American perspective, and I trust that Gary will fill us in on the ramifications for England. But it was an interesting fact that immediately after the Americans declared independence from Great Britain, the majority of the states put the provisions of Article 39 directly into their constitutions. And I'm glad that David highlighted the provisions of Article 39 and what they say, that no free man eventually became no one, is to be deceased, etc., except by the judgment of his peers or by the law of the land. And the Americans put that directly into their constitutions. Mainly, what they had in mind by that was trial by jury. But the link between Magna Carta and trial by jury was sometime developing. And to discuss that, I'll have to go back a little bit into the English history. The barons at Runnymede in 1215 certainly did not intend to apply ordinary trial by jury to themselves. Trial by jury did not exist in criminal cases in 1215. It hardly existed on the civil side. What they meant by judgment of his peers was that they themselves should be tried by other barons. Over time, that came to mean the ordinary common law jury. But it did take a while. In the 14th century, there were a series of important statutes passed by Parliament that introduced the concept of due process of law, and that was what Magna Carta had intended to preserve. And it wasn't until the late Tudor period, so the late 16th and early 17th century, that Magna Carta became linked with trial by jury. And this was a period in which antiquarians were looking back into English history and trying to discover what they thought of as the ancient constitution of England. And one of the things that made up the ancient constitution was trial by jury, and they found it in that phrase in Magna Carta, judgment of his peers. Edward Coke famously seized on the link between Magna Carta and jury trial in his fight against royal prerogative in the 17th century. Americans were very taken with that link, and in particular by Coke. And they used it extensively in their struggles against the British government. The Americans thought of themselves as having an ancient inheritance, a birthright as Englishmen in the fundamental laws of England, and especially Magna Carta. They were interested in Magna Carta for two main reasons. One, as a general symbol of limited government, and government constrained by a formal document. The other was the idea of specific rights, and in particular, trial by jury. The Americans were especially concerned that the British government had been introducing juryless courts in America, the admiralty courts, to try customs cases involving customs laws. Americans were not happy about paying customs taxes, and they felt that they were not represented in the British Parliament, and that they should have a say in that. And there was a great deal of jury nullification going on. American juries refused, essentially, in many cases, to allow that sort of taxation. What Americans would do, an American smuggler would sue an English customs officer for trespass, and that would be tried to a jury. A colonial governor of Massachusetts complained bitterly that a trial by jury here is only trying one illicit trader by his fellows, or at least by his well-wishers. So there was certainly in America a great deal of interest in jury nullification, and in the idea of juries as a form of self-government, because they were not represented in the British Parliament. This was one way in which the people, the American people, could have some sort of say in the way that the law applied to them. And therefore, they were very eager to put this provision of Magna Carta directly into their constitutions. And it's interesting, you see cases in the late 18th and early 19th century in the US that are actually needing to interpret that language of Magna Carta from the 13th century to disputes in the 18th and 19th centuries involving jury trial. So the difficulty was that gradually over time, jury trial was thought to be problematic, in particular on the civil side. The self-governing aspect of juries became less important as Americans developed republican forms of government. In addition, jury nullification was viewed as deeply problematic. These were laws now that had been enacted by representatives of the people in accord with constitutions, which themselves had been ratified by the people. And so jury nullification was viewed as not so much a triumph, but a problem. In particular, it proved a problem in commercial cases. Juries often nullified laws about collecting debts, which many viewed as problematic to the commercial development of the new republic. And so gradually over time, the emphasis on Magna Carta as a law shifted from specific rights, that is specific rights like jury trial, to a more general notion of constraint on arbitrary use of power by government.
So, Renee, then Magna Carta was revolutionary in the UK context, but became revolutionary in a different sense, I guess, is what we're saying in the American context. Gary, what happened to it in Britain then, or what became Britain?
Thank you very much, and to previous speakers. Can I begin by making an observation about British social life in general in 2015 and track back just a little bit? If you spent 8 hours a day reading English law and the rest of the time resting and eating and recuperating, it would take you just under 600 years to read all of the laws that apply currently in England. And of course it would take probably longer than that, because by the time you got to the end of your 600 years, most of the law that you'd read in the first 200 years would have changed. The significance of it, I think, is this, that law is arguably the set of rules by which society coheres. It becomes a civilization. So it's of preeminent importance. And most people don't know any more about law, the details of the law library, than they would know about inorganic chemistry. So what they do know about law becomes immensely important for the way that they define themselves as a society. Britain is widely regarded, along with the United States, as a pinnacle of civilization in the sense of its hallowed respect. There are obviously exceptional cases, in principle, to the rule of law and due process. And it's arguable that this is very much more symbolic than it is instrumental. In other words, people have a conception about their society, and that originates in this particular document, as Philip was saying at the beginning, talking about a minute part of human history written out in Latin that's had such an enormous and resounding and continuing repercussion throughout common humanity, especially when you consider that of the 63 chapters, only 3 are extant today in English law. One applies to the church and is very obscure. One applies to the City of London, the square mile, which is again very narrow and obscure. And one of them, which was originally 2 articles, now is compounded as one, applies to due process and to the principle that no one should be denied justice, or justice shouldn't be the subject of commercial to corruption, to commercial activity. So the importance, I think, of it can be judged in another way. If you take something like the Bill of Rights, our Bill of Rights in 1688, it's variously put because of different calendric calculations of this as 1688 or 1689, but it's one piece of legislation, and it does enormously important things. It limits the power of the sovereign. It insists that Parliament is convened regularly. It insists that nothing said in Parliament can be impeached in any other setting, for example, a law court. So it's at the cornerstone of democracy, freedom of speech in the legislature. The punishments can't be cruel or unusual, which is again a phrase which has repercussed through the judge. All in this 1688 document. Now, how many times has that been cited in the law courts in Britain in the reported cases? And the answer is 59 times since 1688. It's been cited in 59 law reports. Magna Carta has been cited much more, 257 times in the English law reports. It's 900 times in federal and state reports in the United States, 900 citations in the higher reported cases, 257. But when you set that against the general run, the volume of reports, it's minuscule. So, for example, there are 1 million case reports under British law, higher courts precedent-setting decisions, 1 million, and we have 257 citations of Magna Carta. So you could say instrumentally, it's been very little effect, and it's even smaller. Arguably, obviously, opinions academically differ on this, but fewer than 20 cases have been resolved on that point, where it's been cited in 257 cases, but it's been determinative of the outcome in fewer than 20 of 1 million cases. But its comprehension by citizens at large of due process every time they interact with a school or a bank or become involved in a civil dispute or a criminal expectation of the right to representation or trial by jury is immense. And because of the narrative of the way this is taught to people in education systems from an early age, it can have a very powerful impact on thinking as people move into citizenship. And its effect, as David was saying at the beginning, on the way that people behave because it is so deeply installed. In other words, what at one time was described as the sting of the smack of government, arbitrary government that had adverse effects on population. There is a social psychological limitation on that, arguably, because of the way that this principle has been installed in the psyche and the social psychology of British life. Let me finish with a couple of brief points to do with the trajectory of this through history. There have been times, you could plot many points between 1215 and where we are 800 years later, where there have been significant augmentations of this principle or adaptations to a new social ecology. Scores of them. People would differ on the most important ones. But that it's an organic, it's not inert, it's an organic principle. It changes according to the circumstances of history. So, for example, it wasn't long after that first iteration of to no man, to no free man, in the reign of Edward III, from 1369, in fact, through the 1370s, where different versions of the Declaration were iterated, that it went on to say, no man of whatever estate or condition he may be. So quite early on in that story, it's enlarged from one social subset to a much larger group, and you come all the way through to somewhere in British history, like 1828, let's say, when women got the vote on the same basis as men. There's civilization process where the rights are extended. Brings me to a final point about looking forward. I think the one thing that'd be interesting to hear views on is consider the past and remember the future in that historical twist of things, to look at what the trajectory would be if we were writing one of these documents today. What sort of thing would go in it in the light of the experience of the last 800 years? My own thought as an example of that would be that the hallowed precept that no one is above the law, which you might say is the kernel of this, has been widely established. That's axiomatic in many societies. Unfortunately, in some societies, there are a significant number of people below the law because they can't afford to get it. So in a place like Britain, you've got very large parts of the population who would find access to law very difficult indeed. Access to law. So one precept for modern Magna Carta might be something like no one is below the law.
Can I just say that, of course, one interesting thing is that precisely in the resistance to the government's changes on legal aid in Britain, Magna Carta is cited because, of course, Chapter 40 actually lays down the principle that justice shall not be sold, and therefore you can extrapolate from that and say that justice should be free, and the Magna Carta has been called in aid very, very recently this year to resist the government's changes to the legal aid system.
That's exactly where we're going to go with our next contribution. So we're thanking Renee and Gary for that insight into some of the legal complexities. We're going to come on to Marvin now and then Scott. Can we broaden it out, Marvin, to talk about broader governmental and constitutional and political context for thinking about Magna Carta? Where would we place it?
Sure. Well, thank you first for having me. It's a pleasure to be here. And I'm going to approach your question. Ultimately, my conclusion is that substantive due process, as interpreted by the Supreme Court of the United States, is like the lasting legacy, if you will, from Magna Carta of 1215, even though obviously it's been through centuries of interpretation. But when I was invited to do this, to kind of backtrack, the question I asked myself is, why are Americans celebrating Magna Carta? And not just because of the historical affinity we have with Great Britain, but why? What is the core, what is the essence of our attachment, if you will, to this ancient medieval document? And I started thinking, as I did a bit of research and I started kind of reflecting on my own thoughts about this question, is that, in essence, what I think the significance is in the modern time and our postmodern 21st century is that we have a reimagined Magna Carta. In other words, we have a distinct American version of Magna Carta that lays the foundation, if you will, for American law and society. So the Magna Carta, as it initially was articulated in 1215, is a product of a medieval world with medieval politics, economics, social and cultural dynamics that are, if you will, a snapshot of that world. Yet somehow these principles have transcended space and time. We have 8 centuries. So how is that the case? And I came to a conclusion, it's tentative and subject to critique, but in essence what we have is an American Magna Carta. And that version is a distinct sociopolitical, economic, and legal construct, in my opinion, that has affinity and parallels the English Magna Carta, but nonetheless possesses an independent legacy, if you will. So Magna Carta is indeed, in my opinion, inextricably woven into the fabric of American identity, of American society, but it is has an American gloss, if you will. And so I'm just going to briefly talk about how I reached that conclusion and then transition into substantive due process as being the uniquely American, if you will, contribution to the evolution of Magna Carta as far as having relevance in the 21st century. So I view Magna Carta much more than just as a document. It, for me, captures, if you will, kind of the deep complexity of how and when human beings attempt to organize their affairs, how they attempt to resolve conflict, how they attempt to politically, socially, economically make sense of their organization. And so what I found, though, is that there's kind of a misnomer that Magna Carta from 1215 somehow made its way through 8 centuries of space and time, and we find that we have some like the similar meaning, the similar purpose, the original intent, if you will, of Magna Carta. I don't see that. What I think it's kind of it's been called the Talisman of Liberty, the Great Charter of Liberties. But as was mentioned by other speakers, liberty was very, very narrowly construed when it was originally constructed. It's an elite document with elite actors, with elite interests, and has absolutely no connection to the populace. But we now have substantive due process in the United States as, again, applying to every person, every legal person in the United States, to include corporations as well as human beings. And there are even efforts I'm aware of that to give non-humans, such as primates, legal personhood within courts of law. That, for me, is an absolutely fascinating reinterpretation, reimagination, if you will, of Magna Carta as it was initially articulated in 1215. And what I found for me is that there's an imbrication of myth and history that has given rise to this very unique Magna Carta that I would claim is an American construct. And so while it has parallels and it has affinities to the original Magna Carta, it nonetheless has taken on an independent force and trajectory that the medieval mind could not, in my opinion, have ever imagined. So it's been reimagined. And so the founders of the United States seized upon a reimagined Magna Carta that Sir Edward Coke himself reimagined it himself after the original Magna Carta, after it was reissued. And then the founders seized upon that reimagination and reimagined it again. And now we have a document, the U.S. Constitution. And I think the Articles of Confederation and the Declaration of Independence also enshrine this American understanding of Magna Carta, of due process of law and rule of law in particular. But you have a very distinct interpretation and reimagination of what is due process of law. And so the transition to the modern age for me is substantive due process. You have here a concept where judges, justices of the Supreme Court, federal judges, and state and local judges as well in America, can find, if you will, unenumerated rights that exist somehow within the confines of this textual document we call the Constitution, and not only find such rights, but imbue them, if you will, with constitutional stature and protect individuals from the arbitrary or even voluntary exercise of state power. And I think that that is the unique resonance, if you will, of the ancient world and the modern world. So the ancient rights and customs that the barons referred to in 1215 may have had one particular interpretation, original intent, but I think that over space and time, from the founders to their progeny, which is us as American citizens, American participants in the political process, all of us, we really have a very different understanding of what is due process. And scholars have contended with each other here in the United States as to when did substantive due process arise, was it always procedural, and I think those are valid debates, and you can come down on one side or the other, but I think macroscopically, or stepping back from that debate, I think it's untenable to state somehow that substantive due process as a constitutional mandate was imagined and reimagined from an Englishman's understanding of that after it was, again, articulated by the barons themselves. So for me, it's very interesting, this kind of interpretive journey that I kind of took myself to understand, because I really did want to understand, like, why is this so significant? It's an English construct. It's a medieval construct. It was 3,000 miles plus away from our geographic location. It has such distance from us. How is it that Americans seize upon Magna Carta? And in popular culture, it's in The Simpsons. It's mentioned here, The Simpsons show. It's in hip-hop. The rapper Jay-Z took the idea of Magna Carta and put it out there as part of his own show. And while it may not have direct ties to the substance of Magna Carta the way we do as academics, I just find it fascinating that the concept even exists and resonates within the minds of individuals who have never read it. Whether the 1215 version, the translated version, the many issues and reissues that happened even up until the point now where we have our own constitution that has imported ideas and concepts and language of the Magna Carta, Chapter 39 in particular. So I think it's important for us to, at least as Americans, understand what we are celebrating, what you guys are celebrating, and where we perhaps meet as far as our commonalities. But there's some very serious differences. For instance, Americans' due process, substantive and procedural, applies to both the legislature and the executive. In other words, there is no parliamentary supremacy. There is no legislative supremacy here. We have the federalism, checks and balances, separation of powers. I think that all of those concepts, those legal concepts, they're political, they're social, they're economic, and they're cultural, but they find an intersection between themselves in a way that we trace back to Magna Carta, but is a different type of Magna Carta. And so I think the relevance is fascinating as a cultural phenomenon, as a legal phenomenon, politically, economically. For instance, here in the United States, as you may well know, we had one understanding of substantive due process, which was during the Lochner era here, which was the state cannot interfere with economic liberty and economic freedom. Then the Supreme Court changed its view about that, and now non-economic issues, right to privacy, a woman's right to an abortion, etc., are based on due process basis, substantive as well as procedural. And I think that's just very fascinating that we have a development of a concept. So in my mind, it's very clear to me that we need to have a distinction between the English understanding of Magna Carta, what it means for the English polity, and what Magna Carta reinterpreted, re-envisioned by the founders and their progeny, and the relationship between those two Magna Cartas. So I would frame it more as a relationship between two very different imaginations of a very fundamental concept that means a great deal to you, but also means a great deal to us, but in similar yet very dissimilar ways. And so I would just leave off with the two contributions or the two themes that persist, even though they have changed radically, is rule of law. That is inescapable from Chapter 39 and to Chapter 40 about selling justice, if I'm correct, and due process of law, both substantive and procedural, because ultimately it seems from an American legal and political culture perspective, fairness, justice, and impartiality are these ancient rights that the barons apparently talked about back in 1215. I don't think they did, but that's what it means to us now in the contemporary age. And so we attribute the reimagined Magna Carta to the original Magna Carta, and that perhaps may not be accurate, but I do think that there is room for finding those parallels, but we need to be very clear on the distinctiveness between the two. So I'm not sure if that is in line with the question you asked me, but I think that's how...
That is an extremely illuminating stateside perspective, Marvin. Thank you very much. And it's prompted something I want to perhaps raise at the very end, but I'll try and link you up now with Scott Kelly to see if Magna Carta survives in the British polity in a similar way or a different way, given our rather different national arrangements. Scott.
Thank you, Philip. That's a very useful introduction. I want to apply some of the thinking about Magna Carta and some of the interesting points which you've made so far to contemporary debates about the British political system and the Constitution. I just want to start off by saying that in Britain there seems to be a great deal of confusion about what the Magna Carta means, sometimes even literally. A couple of years ago, the Prime Minister David Cameron appeared on David Letterman's show in America and was unable to tell Letterman that Magna Carta was Latin for Great Charter. It was extraordinary considering he studied Latin at school. And many older British people still remember the comedian Tony Hancock's impassioned speech to the jury in a television parody of the film 12 Angry Men, where he said, "Does Magna Carta mean nothing to you? Did she die in vain? Brave Hungarian peasant girl who forced King John to sign the pledge at Runnymede and close the pubs at 10:30. This comedic confusion, I think, points to a genuine ambiguity about the historical constitution and constitutional significance and status of the Magna Carta in Britain, but also to the importance, I think, of the myth, because this was obviously his big point he's making to the jury in this parody. And I think we've already had a very good contributions explaining some of the reasons for this, particularly the divergence perhaps between Britain and America in the 17th and 18th centuries, where the Magna Carta was very important to debates about the royal prerogative, and then was transferred to the American system by the colonists. But of course, it was then the idea of no one being above the law. The rule of law was then entrenched through the Declaration of Independence and in the US Constitution. But Britain, on the other hand, England and then the United Kingdom, doesn't have a written constitution, and it has the principle of parliamentary sovereignty and of parliamentary supremacy. And this means that the relationship between the rule of law and Parliament is very different to the situation in America. There are reasons, I think, for thinking that this relationship between the rule of law and parliamentary supremacy is becoming increasingly problematic in the British context. And Tom Bingham, a very distinguished former law lord, wrote about this in a book on the rule of law, which was published shortly before he died. I just want to point to three in particular, one which is very political, or two which are very political, and one which is more about a legal, more legal in its significance. The first is that the way in which the British system of government is commonly understood is changing, and this is creating democratic problems. In particular, Britain, in the post-war period, in the period after 1945, had single-party governments, and the idea was that this government had a mandate because it was elected by a majority. Of course, that majority, in fact, was often a plurality. It was more people than voted for other parties, but at least people believed or felt that the government had a legitimacy, and therefore it had a direct relationship to the people, which is very important in this context. We now have a coalition government in Britain, and we have a general election, and the likelihood is that after the general election, we'll either have a minority government, which then has to work with other minor parties in Parliament to govern, or we will have another coalition. So this direct link between the public, or the perceived direct link, is probably a better way of putting it, between the public will and government, and therefore justifying in a modern context, legitimizing in a modern context the idea of parliamentary supremacy, is being weakened. And this might become an important issue, I think, in British politics in subsequent years. It depends on what happens, of course, but I think there are reasons to think that. Second, and related to that, is debates around Scottish independence. As you'll know, there was a referendum on Scottish independence last year where there was a quite relatively decisive vote against Scotland becoming independent, and yet this is still a very major part of political debate. And in fact, the Scottish National Party, the party which wants Scotland to become independent, it seems, if opinion polls are correct, likely to overwhelmingly win in Scotland in this general election on May the 7th. There's a problem here, I think, because Britain doesn't have a written settlement. Any attempt to resolve the relationship between the rest of Britain and Scotland is likely either to be a piecemeal settlement or complete separation. It's very difficult within the context of parliamentary supremacy to imagine a settlement which isn't one or the other, which is either a piecemeal settlement or one which results in complete separation. And therefore, I think that this is the reason why this is relevant to this question. The third is there is increasing tension, I think, or it's been widely written about, between the executive in Britain and the judiciary. And this could become more pronounced if a future government, and this is part of the Conservative Party's manifesto, which is one of the two main parties in Britain, were to repeal the Human Rights Act, which entrenched the European Convention of Human Rights into domestic law, and the Conservative Party is actually committed to doing that. Some senior judges, members of the Supreme Court, have already raised the possibility that there may be some principles which are above parliamentary sovereignty, relating to the rule of law. And this came into stark relief in a case about 10 years ago, which was actually about fox hunting. Fox hunting was a very impassioned issue in Britain, but in this case, Jackson versus the Attorney General, 3 members of the Law Lords, which was then the highest court, made arguments which stated there may be grounds in which courts would disapply domestic law if they felt it was in contravention with the rule of law. Baroness Hale argued that the courts will treat with particular suspicion and might even reject any attempt to subvert the rule of law by removing government action affecting the rights of the individual from judicial scrutiny. Others, Tom Bingham in his book, and other scholars have argued, like for example Vernon Bogdanor, a constitutional scholar, that there is no basis for this, partly because parliamentary supremacy is so well entrenched in British practice, and also what is it the judges are appealing to above parliamentary supremacy in the absence of a written constitution. So just that, all of that leads me to one final point. The Magna Carta, in a sense, in its relevance to this debate, is partly about the myth of the Magna Carta. After all, nations are... I was just going to... My last point was really related to what Marvin was saying about the Magna Carta being reimagined and the importance or the possibility of reimagining the Magna Carta for a new generation. The Constitution Affairs Committee of the House of Commons in drafting a written constitution referred to it, we can see now, as a new Magna Carta. And its status of Magna Carta as a written document is very significant in that context. And just imagine the scenario if the day after the referendum in Scotland last year, where Scottish people voted to stay in the Union, rather than coming out from 10 Downing Street, as David Cameron did, and calling for English votes for English laws, in other words, trying to deny Scottish members of Parliament a say in matters pertaining to England, he had actually made a much grander call for a new Magna Carta, for a new written settlement for the nation. Maybe that would have started a much more productive debate about the way forward, which would have great relevance to a lot of the dilemmas which we're currently facing as a nation.
Fantastic. All our speakers have been absolutely on time, which means we have our whole final 10 minutes to start talking a bit more to each other. Can I get us going with a question which kind of follows on from the dramas to which Scott is just alluding in Britain, but also has extraordinary relevance for the States. In the wonderful television programme by David Starkey, we've been showing this week, David Starkey, having given us the history of Magna Carta, underscores what he sees as its contemporary symbolic importance by reference to the bigger global scenario and specifically the war on terror. And he says all the gains and the derivations that we celebrate from Magna Carta are now thrown into stark relief by the way law and governmental action has been obliged, it is argued, to change the game because of the increasing threat of global terror. And I just wonder if that's a starting point. It's not intrinsic to Magna Carta, but it arises from all the issues that you've been sharing so far.
Can I make a point of that? In a way, it is implicit in Magna Carta. The problem is there, because the most famous chapter of all, chapter 39, says no free man is to be outlawed, imprisoned, or private property, save by lawful judgment of his peers, or by the law of the land. Now, in 1215, of course, the law of the land was seen as a barrier against the executive, because the executive could not change it. Whereas, of course, it's a totally different situation in Britain today, where the executive can change the law of the land if it has a parliamentary majority, as it wishes. So the executive can deprive you of any right to due legal process if it wishes, if it can, because the executive may control the legislative. And that does raise the absolute profound issue, which I think is what Magna Carta is asking us today, whether in Britain we need, as in America, a new Bill of Rights which precisely stops the executive doing some things, even though it controls the legislature. And I think one of the profound insights of the founding fathers of the American Constitution was that the danger is not just from the executive, it's also from the legislature. And that's why the American, of course, Bill of Rights precisely has some things which neither can do. And that's, I think, the issue facing Britain today.
Can I bring Renee in? Renee, in the David Starkey film, he's got some dire warnings for Britain, and in the case of the States, his watchword, of course, is Guantanamo. And I just wonder if you can give us an American perspective.
Well, I'd like to, if I may, if it's not too presumptuous, I'd like to caution the UK about introducing specific procedures into a constitution. I think the phrase due process of law captures a lot of what's needed. And interestingly, as Marvin suggested, that phrase has been interpreted very differently in Britain and in the US. And I'm reminded of a debate that occurred in the US in the late 1970s and early 1980s, in which Patrick Devlin was involved, Lord Devlin, a British judge. And Devlin remarked that what due process meant to a British person is the process that is due, that is the process that is specified. He was shocked to discover the American interpretation of due process, even procedural due process, that courts could actually tinker with the procedure to a certain extent, or declare it inadequate under the Constitution. He was shocked at that notion, and he must have been, therefore, even more shocked at the notion of substantive due process, which Marvin talked about. I do think it's very important to preserve a degree of flexibility in the Constitution, and I highlight for you the American Seventh Amendment. We have entrenched in our federal Constitution a right to civil jury trial, which many people believe today has not served us well in terms of the operation of our civil justice system. As you know, it has effectively been abolished in Britain for everything but defamation. And you've substituted bench trial instead, which I think many people regard as a more efficient way to conduct civil proceedings. That's just one example. There are others. For example, the grand jury requirement in the Fifth Amendment of the U.S. Constitution, which is also viewed in many instances as problematic. And so I would suggest to you that to the extent that you want to constitutionalize procedures, that you make them general in nature and not specific, because a procedural system is a whole, and if part of it changes, then that affects the parts that have been constitutionalized a great deal. So I would caution you about that, if I may.
Mary, is that a relevant warning for Britain?
I think
I
think it's a very wise caution. I agree. I think it also raises an interesting question about the future, as we've been turning to survey the last 800 years, and we turn to look at the succeeding 800 years. What will change, if anything? Arguably, one of the most important superventions post 1215 has been the advent in its named form of human rights. Because whereas due process from 1215 onwards is content neutral, it's not political, it just says that whatever the rules are, the law of the land, you have to obey those rules. They prevail over the capricious rule of any despot. Everyone knows where they stand because you've got the rule book and no one is above the law. And that runs on, and it's a hugely civilizing force and stabilizing force, but it's content neutral. But then you get later on in history, during our lifetimes, or over a short distance, the idea that law can be, alongside of this due process precept, prescripted to a certain extent as to the content in relation to human rights. So you can actually say what goes into the law. Slavery is something which should be condoned by no law. that people have the right to life, and it's given a narrow construction so far. It means you can't, if you're a public organisation, do something which would almost inevitably result in death by the way that you're treating someone in a prison or because of their prescription pills or something. You can't do that. But the right to life doesn't at the moment include the right to food or shelter or other things. So the question is, will laws ever reach the stage, or should they, where the next part of human development goes to the content? I exactly agree with René's caution that due process is something which should be narrowly honoured, and you don't want to go too far in that. But alongside of that, it raises the question of the advent of human rights. Should they be about to perish, wither on the vine, or will they should they in future be allowed to develop?
Anyone like to pick that up? Marvin, we're coming towards the end, but can you offer something more on that?
Just a quick comment. I was just reading, had a couple quotes here that I was reading if I had the time, and I didn't, but just reflecting on this question in the Starkey film, I think that the ancient and fundamental right concept that pre-exists government, that pre-exists, let's say, political organization, that are natural rights perhaps, those rights are an effective counter to the exercise of state power. In other words, national security, emergency does not trump fundamental rights. Could be an argument that you can make going from 1215 to 2015. And I'm reminded here of Justice Harlan of the Supreme Court in 1961 in Poe versus Ullman. He was dissenting. I think he makes a really good point, which is, were due process merely a procedural safeguard, it would fail to reach those situations where the deprivation of life, liberty, or property was accomplished by legislation, which operating in the future could, even the fairest possible procedure and application, nevertheless destroy the enjoyment of all three. So in other words, I think we are far too complex in our human organization and our societies to relegate ourselves to text, and I think it's absolutely imperative that text be viewed from a more flexible perspective. And I think the Magna Carta's notion of these fundamental rights that transgress monarch, that transgress legislature, that transgress executive power, then executive power cannot rely upon security and emergency to trump those rights, because those rights supersede, pre-exist. You can have a Platonic notion, you can have a positive notion, but in the end, if you adhere to that original sentiment and how it's been reinterpreted throughout 8 centuries, I think that says a lot for our capacity to not get trapped within the specifics of language and to read into language the flexibility that human affairs require. So I'm just making a case for Magna Carta relevance and application. Even if it's a medieval construct, it certainly has a very serious and profound application if we take it seriously, not just as theory or principle, but in practice.
Okay, I think I'm going to lead us to a conclusion by coming full circle. Everyone's had wonderfully expert and phenomenally complex things to say, so I think I'm going to take us back to basics in a way, and I'll go back to David Carpenter. You've had privileged access to this whole story in your scholarship, David.
Yeah.
Can you give us some closing words to try and draw this together, if that's possible?
I think it's to actually look at the 4 originals of Magna Carta together, as I've been privileged to do, and actually handle them in the same room. One from Lincoln, one from Salisbury, one we now know from Canterbury Cathedral, and one we don't know where it comes from, but it's in the British Library. It was a very, very moving experience. I didn't expect it to be, because actually I've seen them all individually, but to see them together is really a very moving thing. And I think it's very moving to go to Runnymede itself, where the great aeroplanes taking off from London Heathrow Airport, they come up over Runnymede, and then they turn and they fly down the whole of its length before they disappear into the distance. And in a way, that is taking Magna Carta round the world, and that's what's happened.
A very, very nice way to finish. So we're going to stop there, I think, friends. We thank René and Marvin very much indeed at Washington End. We thank our colleagues Scott and David and Gary here, and the unseen audiences at both ends as well. Thank you for being with us tonight. Thanks very much indeed. See you again soon.
Thank you for having us. Thank you. Take care.